The Business Innovation Zone, also known as the Biz, is the place to start for entrepreneurs in Iowa. The Biz helps entrepreneurs and startup companies focus on idea development, business models, strategy, market validation, mentoring, and networking. We also help clients connect with qualified community and state resources needed to grow their business. Throughout the year, we provide a number of networking opportunities with experienced entrepreneurs and business leaders by offering monthly luncheons and all-day seminars on marketing and finance. You can learn more about the Biz at bizci.org.
Thank you very much. And my colleague Joe Leo is back there in the suit, and we're going to kind of tag team this a little bit. So I may ask Joe to weigh in on some things, and you can feel free to ask Joe to weigh in on some things. One thing we're talking about securities laws and raising capital. We're going to try and make it not nearly as boring as that title sounds, because that's just god awful. A lot of pressure following Ben. I've had the pleasure of working with Ben and JD on these raises, and so. Any question that you might have for any of the other speakers, feel free to raise it in this context, because first of all, I have an opinion on everything. Second of all, I like as a lawyer to think like a business person. If you meet with your lawyer, and it's hard to do in the securities law area because it's compliance, right? But if you meet with your lawyer and you find that they don't think like a business person in your capital raises or any other aspect, then you've got a problem. There'll be a disconnect. And so I want to make sure this is interactive, make it as interactive as you can. Any question you want to ask is great. So I'm the managing partner at Brown Winnick Law Firm. We have about 60 lawyers over there. I practice in the securities area. I don't usually introduce myself that way because I help people raise money. And then I have to follow that up with, I help them with the legal side and the business side of raising money, because then they always ask me, well, who can give me money? And that I don't do. But I do. Des Moines and Iowa are small communities, very connected, very networked. So some of the people had asked some questions that made me think one of the things you need to keep in mind, whether it's identifying those 4 people or doing anything else, is it's a close-knit community. If there's somebody local that you want to know, find somebody that you do know and work your way to them. It's easy to do. It's easy to do. So if I can ever help any of you to meet anybody locally or otherwise who can help your business, let me know, because I'm happy to do it. There are experts in Des Moines. Don't be fooled that the coasts are where you need to go to get expertise on venture capital or on angel investing or on any other kind of issue that you confront. There may be a smaller group around here, but the expertise is here. And I'll also tell you this, I'm pretty well off script here, but you will find that the people on the coast or anywhere else who are the identified experts usually don't know as much as they want you to think they know. Usually their answer of, well, that's market, well, that's the way it's done, well, you haven't done as many deals as I have, that's just the way these deals are structured. Not true, not correct. So, and your response can also be, you know what, I don't care if that's how it's usually done or if that's how you've always done it. This is our deal and our negotiation, and we're going to do it in a way that makes sense for both of us. So, my practice is a securities practice, is also an M&A practice. Transactional practice. I think it's important that your lawyer have that experience as well, because when you're structuring your company, before you even get to a capital raise, you need to structure the right company. You need to structure it anticipating what your business strategy is. Are you going to want, if it's, again, as Ben said, lifestyle business, we're not really thinking very much about raising capital then. We're certainly not thinking about raising capital from VCs. A lot of people come into their business and they immediately think, I need to be prepared to raise money from VCs, so I'm going to be a C Corp, and I need to do these things. Not necessarily. In fact, the levels of capital that people were talking about here, we're probably not, for the most part, talking about VC money right now. So think about what is your capital need. One thing from a legal standpoint, this is legal and business, I think you want to, when you're raising capital, think about raising the right amount, because it's very expensive, and the earlier you raise it, the more expensive it is, the more dilution it costs you, from the right investors in the right manner and process. Those are 3 things that really play into what we're talking about today. The right amount of money from the right investors, and we'll talk about what the risks are from different types of investors, and in the right manner. So I mentioned in here transactional M&A lawyers. Of course, I imagine that I say nice things about people who do what I do. business and deal guys. Those are what I think you want in a lawyer, even whether you're raising capital or not. Securities lawyers, people that are the pure securities lawyers, they're the ones who are the compliance guys. Okay, there's a lot of reasons I can tell you, a lot of things I can tell you cannot do. And unfortunately, because of the nature of this topic, we're going to tell you some of those. But what we're going to try and focus on, and what your securities lawyer needs to focus on, is how do you do what you want to do? Or how can we come as close as we can to what you want to do? So compliance isn't the focus. The deal is the focus. So keep that in mind in raising capital. So this is kind of a cynical view of securities laws. What do? From your perspective, and believe me, from mine as well, they complicate things, they add time, they add expense. If you want to raise $50,000, you're going to be, or $25,000, you're going to be way more interested in the crowdfunding things that are being discussed right now than you are the stuff I'm talking about. But there are ways to go through more traditional capital raise methods than crowdfunding that can protect you and can add value in terms of protection. So it's not nearly as expensive to comply as it is not to comply. The penalties that hit you if you do these things wrong can be really, really strong, and they can include personal liability. So what in every capital raise we're talking about, we have to talk about risk benefit, right? So if you want to raise $20 million, then we probably have a big enough project that we can do it just right. And we can talk about what's just right. If you want to raise $250,000, we probably can't do everything. Lawyers like to tell you how everything could be just perfectly safe. Well, it's not perfectly safe, second of all. And if you come to me and I say I can do this just right, but I need you need to pay $75,000 in legal fees for a $250,000 capital raise, it doesn't make any sense at all. And you ought to laugh at me if I do that. So what we have to talk about is, what levels of protection can we get you? There are different types of ways of raising capital. I don't recall from my slides whether I talk about, but you may do, at a minimum, I'm going to want you to have good organizational documents, good governing documents that lay out the rights of people that are owners and investors in your company. So you want to get those right, and you want to get them right from the beginning. Second thing is, if you're out raising capital, how do you do it? At a minimum, I want you to have a subscription agreement, which is based on the securities regulations, and it's going to reduce your risk somewhat. It's a modest document. It's a fairly canned document, but you got to have it. In certain deals, a term sheet is something more than a subscription agreement. It's in addition to a subscription agreement, but it's more protection, more disclosure. Finally, you get to a full-blown PPM or prospectus. So as I said, a little bit of compliance provides a lot of protection. Just a quick basic, what's a security? So when people say I'm a securities lawyer and I help you when you sell securities, some people think, well, I'm not selling securities, I'm selling stock, I'm selling LLC units, I'm just raising money through notes. All of those things can be a security. So a security is just basically, I'm going to say a scheme, and I don't mean that in the negative way, where the investor has an expectation of profits, common enterprise from the efforts of others. That's one of the big things. So one of the things we might look at, and your lawyer should look at right from the beginning, is this a security at all? Do we even need to be talking about compliance with securities laws? We've got other things to worry about, like we don't want to defraud people and we want to give accurate disclosures and that sort of things. But most often, if you're able to, if somebody's going to be active in the business, you may get this solely from the efforts of others. You may fall outside of that, and you may not be a security. But most often when you're raising money for third parties and they're expecting to make a profit from what you do, that'll be a security. And then you get into this mess of securities laws. It's state and federal. There are registration requirements and exemption requirements. For purposes of this group, I'm going to focus almost exclusively on exempt offerings, meaning you won't have to do a registration with the SEC or with the Iowa Securities Bureau. If we got to that level, I'm happy to talk to anybody about that at any time. We've done a lot of registered offerings at our firm, but for the most part, what we're talking about here, they'll be exempt. And frankly, registered offerings are complicated and extremely expensive. Sometimes the state and federal laws work together, and sometimes they don't. So when somebody says, Is there an exemption? So can I go out and sell my securities? We need to know where you're selling them. We need to know who you're selling them to. We need to know a lot more than that. Sometimes the regulators work together and sometimes they don't. If just because you qualify for a federal exemption does not mean you qualify for a state exemption. And just because you qualify for a federal exemption and a state exemption in Iowa doesn't mean you qualify for one in California or New York. I have a current offering ongoing right now where they're raising about $16 million in a private offering. As is sometimes the case with the economy still being a little bit stagnant right now. This is a really interesting deal, and sophisticated investors are getting in, investing large amounts of money, but they haven't. Their thought initially was, well, we probably look at these 5 states. Well, we've now probably looked at 17, 18 states because they're getting close, but they're maybe at 15 million now, and it's always surprising to them when they hear, yeah, you're fine in Ohio, but you're not fine in California. And so your attorneys need to know where you're selling. So you need to have a registration or exemption both at the federal and the state level. Oops. I'm not sure what I'm doing wrong there. We'll skip that. Actually, I've got a hard copy right here. We'll figure out what I'm talking about there. The exemption and disclosure requirements vary depending on who you're selling to, where you're selling, and how much you're raising, okay, and who's doing the selling. For most of the offerings you folks are talking about, I'm going to assume that you're doing the selling, doing the capital raise yourselves, or through a more local investment banking type advisor like JD, who may be actively involved in your offering. When I say who you're selling to, what I really mean is I'm focusing on sort of rich, sophisticated, not rich, not sophisticated. That's kind of the spectrum. So the securities laws are generally out there to protect the less sophisticated, the less wealthy. So you will find if your lawyer who's advising you knows what they're talking about, they're going to be more comfortable if you're selling to rich folks, VCs, that sort of thing. If you're selling to sophisticated investors, they're going to be less comfortable and advise you to be much more cautious if you're selling to less sophisticated, less wealthy people. So I envision the range as sort of the VCs that just invested in Dwala. Those are sophisticated folks. Their need for a disclosure document, I mean, trust me, their due diligence is their disclosure document. They know everything they need to know by the time they get done. Versus pick the 86-year-old neighbor lady with blue hair, and she's got $20,000 under her mattress, and that's her last $20,000. If at all possible, I'm going to advise you, and your other advisors will hopefully advise you, don't take her money, because she is not an appropriate investor for the types of activities we're talking about here. She should keep that money. She probably ought to get it out from under the mattress, but that is a high-risk investor. And then how much money you're raising and who's selling it. So here's the next slide that we got to. These are the most common federal exemptions. I'm not going to talk about the specific state exemptions because, again, they vary from state to state. 504 is an exemption for under $1 million being raised in 12 months. You'll find sometimes we talk about these 12-month periods because I talked earlier about raising the right amount of money. So raising the right amount of money is important because the SEC and the securities regulators, they sometimes they do something where they integrate your offerings. So you do one offering, and then in a short period of time, you do another offering, and they look a lot alike, and they're kind of for the same purposes. Integrated offerings are treated as one offering. And so you'll hear us sometimes talk about integration, and what we're really talking about is you may have qualified for an exemption. Let's say we're working under 504, so we're under $1 million in 12 months. So you raised $600,000 January 1st. You didn't calculate your needs well enough, your sources and uses. Now it's anytime this year, December, and you need another $600,000. You will blow your 504 exemption. meaning that prior offering and this new offering will be integrated and you will have just lost your exemption. Doesn't mean you don't qualify for another exemption, but that's why we'll sometimes stack these. And so what we want to do is we want to qualify for as many exemptions as we can. 504 is a very common one. There's not much disclosure required. We will always advise you that your disclosure to your investors is kind of your insurance policy, informal insurance policy. You want those people to know at a minimum that there is a risk that they can lose all of their investment. You want them to know that. I want you to let them know that in a written document. And I will want you to say that as clearly as you can. And you'll talk to your lawyer who's helping you. Let's assume you're putting together a prospectus, a PPM, which means private placement memorandum. They're called all sorts of things. You're used to drafting your business plan going in and trying to get a loan. And your business plan or your executive summary says all the great things you're going to do. Here's how we're going to execute, and that's why we're going to be successful. And then you go to your lawyer, and they put a big skull and crossbones on the front of your prospectus and say, do not invest. It's not quite that bad, but sometimes it feels like it is, because your disclosure document, whether it's a term sheet, whether it's a PPM, whether it's a registration statement with the SEC, your disclosure document is intended as a risk disclosure to your investors. It's to describe your business, and then it's to as specifically as you can within reason. Again, remember the $250,000 offering will not get the same amount of disclosure as the $250 million offering. But we'll want to tell people as specific risks as we can and as realistic projections as you can. You want to tell them your business plan. You'll get a little bit of your business plan in there, but then right after you tell them your business plan, what you really want to say is, and why that's a great business plan is this. Actually, what you're probably going to say is, and why that business plan may fail is this and this and this and this. It's a balancing act. So I'll want you to do more disclosure. You'll want to do less disclosure. We'll find a balance, and there'll be some risk. 505 is not a particularly useful exemption in my mind because 506 is out there. 505 you can only sell to accredited investors, which we'll talk about in a little bit. Assume rich guys, rich folks, and up to 35 non-accredited investors, not rich folks. When you get into non-accredited, your lawyer and your other advisors should always advise you, if you can, don't take dollars from non-accredited, because it increases your disclosure obligations. You have to do audited financials, which has a cost and has a delay factor. It also increases your risk. That's one of the things that Joe will probably talk about, and I have thoughts on this crowdfunding thing. One thing about crowdfunding from a lot of small investors, I'm really concerned that most of the smaller investors are probably less sophisticated, and you need to bring more of them in, which means more headaches and more arguments and more potential claims out there because of people who say that they didn't really understand what they were getting into. It's a $5 million cap on 505. 506 is an exemption that frankly, the one that we're probably most comfortable with at the federal level. Again, accredited investors and up to 35 non-accredited. Unlimited amount that you can raise. And 506 has a preemptive effect on state laws. We'll still take a look at state laws for certain purposes, but for the most part, under 506, if you can qualify under 506, you ought to be in pretty good shape under the state laws. The other thing that I don't think I cover anywhere, but I've talked about wealthier, more sophisticated investors being safer and better for you as a company. They're better for you because they understand what they're getting into better. Fewer investors is generally better. You know, you'd rather, we'll usually talk to you about a minimum offering, a minimum investment amount per investor. If you can make that 50, it's better than 25. If you can make it 100, it's better than 50. The higher you can make that minimum investment, you'll have fewer investors, which means fewer questions to answer, both when they're coming in and on down the road. And it also means fewer people, complaining later on. Accredited investors, I want to make sure that we get through all the materials today. We're running a little bit behind. Just a few. Your directors and officers, the real ones, are accredited by virtue of that activity. The reason I say real is because let's be clear that the SEC and the securities regulators, they've seen almost every end around that you try and come up with. So if you think you've got this really brilliant idea that you got this investor and you're going to make them the second vice president in charge of nothing, that will not get you to where you need to be for somebody to be accredited. This is the most common one, rich guys. Persons with net worth greater than $1 million, exclusive of their equity in their home, or income requirements. Interestingly, I will tell you this, securities laws are not a do-it-yourself place, a do-it-yourself area of the law. I looked at a subscription agreement yesterday for a reasonably sophisticated group that's raised a lot of money for a lot of different projects, and it had the look and feel and smell of a good subscription agreement. And the only problem they had is in their subscription agreement, these two letters were replaced with IN, persons with net worth greater than $1 million, inclusive of, which was just wrong. And so if somebody was saying, I'm accredited because of that, you now keep in mind, if you have an offering that you're only making to accredited investors and that's the basis of your exemption, and somebody turns out to be non-accredited, you've got a problem. An entity with assets in excess of $5 million not formed for this investment. A lot of times you'll find people that can't quite fit an exemption, and they say, well, let's put our money together and therefore we'll become accredited. Yeah, that's again a pretty transparent sort of end around. These are some of the most important requirements of exempt offerings. So registered offerings are the ones you read big ads about in the Wall Street Journal, you hear radio advertisements, you maybe even sometimes see something on TV. That's called a general solicitation. That's when you say, there's a big meeting out in West Des Moines tonight and you should attend because we've got a great investment opportunity for you. And you can't have that when you have an exempt offering. This is one of the softer, harder to define standards, but a pre-existing substantive relationship with the investor, such that you have a reasonable expectation that this is an appropriate investment for this investor. What does that mean? Okay, so that means that you can't do those advertisements that I meant. You can approach people for investment that you know. You can approach people for investment that anybody on your board or your officers know. You can probably approach somebody who you don't know that well, but your advisors know real well, and they, those connections get further and further attenuated, and it's kind of a smell test. I try and disclose to people the kind of a pragmatic analysis of it. But when people get way out there, like they really don't have any connection, but they heard that this guy's rich, no, that won't do it. That might do it in Des Moines because almost everybody knows everybody when it comes right down to it in terms of connections. One point I was going to make earlier also that when Ben was, that I thought of when Ben was speaking, is if you have a good concept, a good investment opportunity in Iowa, and you go to the right advisors, they probably have a network of connections that can legitimately get you in front of most of the more active investors, kind of the angels and more sophisticated angels. However, you should keep in mind that certain people, I think Ben threw out the example of Bill Krause and mentioned Doug Reichert. There's a list of about 40 people in the Des Moines area that every single time somebody comes into me and wants to raise money, but they don't have ideas on who they're going to raise it from, they'll say, well, how about this person and that person and that person? And these names come up over and over and over again. Those people get pitched all the time. And you need to think about, are they an appropriate investor, and do you have a personal connection of some sort to them? Otherwise, you're probably not going to get an audience. So you can't do general solicitations. That's a big one. Limitation on resale, I'm not going to get into that much. It's Rule 144. It basically means if people are investing, you've probably seen the disclosure in either an offering document or a subscription agreement that says you're investing, you're purchasing the securities for investment purposes and not with the intent to resell. There'll be a holding period. These will be, for exempt offerings, there will be a holding period, generally a year for non-affiliates, non-insiders. Informational requirements. This is the full disclosure that I've been talking about. The more disclosure, the better. The more disclosure, the more insurance you have, if you will. By the way, I talk about the disclosure document as insurance. There is other insurance, real insurance, called D&O insurance, directors and officers insurance. if you can afford it, and I will always tell you if you're selling securities, I want you to find a way to afford it. You should have D&O insurance. D&O insurance is hard to get for startups. It's expensive, but it is real insurance, and it's important to protect you. Another thing that's very important is unless they've changed it, and I've got a person in my office who's my D&O expert because I hate reading insurance policies. There were 3 kind of standard forms, one of which, for example, does not cover sales of securities. Don't buy that one, even if it's cheaper, and it is. Doesn't do you any good. If I remember right, the other 2 main kind of standard forms, one covers exempt sales, but doesn't cover registered sales. I should think about that. It's probably the opposite. It covers registered, but not private placements, exemptions. When we talk about exempt offerings or private placements, same thing. You need the insurance that covers what you're doing. So if you can afford it, you should get it. When people ask me what's the appropriate amount, generally it's as much as you can afford. Most companies that are raising any significant amount of capital are going to have $1 million to maybe $5 million. And then again, full disclosure, that's your other insurance policy. The standard, with a few exceptions, is disclose all material facts an investor would consider important. And then the popular, and any facts necessary to make the disclosures not misleading. More risky investment, more disclosure. It's just safer for you. If you can raise money from people after you have disclosed to them, this is a bad investment and we think you will lose your money. That is a terrible document to go out and try and raise money with. But from a pure legal standpoint, that disclosure is pretty safe for you. Now, it'll never work. I mean, you won't do that. But the less sophisticated investors need more disclosure. The more risky investment needs more disclosure. We'd like you to do a full prospectus, which is a PPM, or that may be 10 pages, it may be 20 pages, it may be more than that. You might need audited financial statements. We talked about if you have, depending on which exemption, and if you have non-accredited investors. The most important thing for you to remember here is if you fail to disclose material facts, it can result in rescission, which means you have to give everybody their money back. The problem, the biggest problem with finding yourself in that circumstance is most of the time some of the money's been spent. And you have to, by the way, you have to pay it back with interest, and you have to comply. It's a state law remedy. So if you've sold in, helped a client with a rescission offering in the last year. I think it was 21 states. 21 states who want you to do it exactly their way, and they don't match up. And so you're trying to make it match up as well as you can. Rescission is a bad thing, but it is a cleansing thing. So if you find yourself in a situation where you realize, for whatever reason, that your disclosure document is materially inaccurate, rescission is the best course of action, because the next point, securities fraud or securities violations carry with them personal liability for officers and directors. Personal liability, just assume your house, your car, your personal possessions. So if in doubt, disclose. If uncertain, disclose uncertainty. The people, if you've got a good business opportunity, a good investment opportunity, and if you're going to reasonably sophisticated investors, they expect all those disclosures that really rub you the wrong way. They know it's going to say that they may lose all their money. They know that you're going to say that it's going to say this is a startup with no history of operations. They know that you're going to say this industry has these risks. They know you're going to say that technology may change, laws may change, the industry may change, and we might not change with it. So they're not going to be troubled by that. I have a very, very, very wealthy client from out in Newport Beach who, very sophisticated investor, older guy, wonderful guy, who, a couple of years ago, he asked me to meet him out at Skip's at, 4:30 on a Friday, at a time where I really didn't have time to be there, but he needed to be there. So I show up, and somebody else, again, back to the thing that everybody that you want to pitch, other people have already pitched, somebody else was supposed to show up there and pitch him for investment, and didn't show up, and instead sent a courier with a prospectus. Your pitch, your personal credibility and integrity is what sells this deal. Now, I don't want you guys going out and saying, the lawyers made me do this, but don't worry, that's not our deal. That's bad. That's real bad. But your personal credibility, integrity, and description, the pitch, is what matters the most. In his words, I don't need to see a goddamn prospectus. I've seen more prospectuses in my life than I ever need to see. He doesn't show up, he doesn't get my money. It was that simple. Restrictions on communications. We talked about no public general solicitations, that sort of thing. I can recall a situation with a client of mine at one point that was doing an intrastate offering. Intrastate offering is an exemption that lawyers don't like very much, because it's really hard in this day and age to say our offering stopped at a state border. It's still an exemption, and it still is used sometimes. And then you're allowed to solicit more generally within that state. Okay, what if you use radio? Now, if it's a localized radio station, maybe. In this case, the client actually posted a billboard on the interstate highway. and they, that happened to come to my attention through somebody from there. They thought that was really smart, and I said, I don't want to be a wet blanket here, but intrastate offering advertised on interstate highway seems to me to be a problem. And so in that case, we ended up doing a disclosure to the regulators. Self-reporting to regulators is never any fun. Not much of a fan of that, but if you have to do it, you have to do it. They required a cooling off period. It wasn't as bad as it might have been. I think it was 3 months or something like that. But when you're ready to raise money and you want to put a spade in the ground or something, and having to take 60, 90 days off is a bad thing. So talk to your lawyer before you make those communications. That's the safest bet. I'm going to go really fast on this. These are called the broker-dealer issues. We talked about exemptions at the federal and state level for your securities offering. The people selling the securities need to be registered or exempt as well. There aren't a lot of registered broker-dealers in Des Moines. LWBJ and JD are registered. What we see most commonly, officers and directors selling without compensation. If you have people who want to raise money for you and they want to get paid for it, they need to be registered. If you have finders, everybody has this, Ben mentioned, don't have other people sell your investment opportunities for you. It's amazing how many people come out and say, I can find money for you if you just pay me a percentage of what I raise. That's, in an exempt offering, that is an absolute no-no unless it's a registered broker-dealer. And it happens all the time. Then they say, no, I won't. I'll just find people, and you don't, the term of art is transaction-based compensation. So it's money paid for raising money. Then people say, well, our agreement won't say that. Well, that doesn't matter. It doesn't matter what your agreement says. And the other thing, now generally speaking, with some caveats, if you want to pay somebody a flat fee as a consultant, not for raising money, and it's not transaction-based compensation, you might be able to do that, but it's extremely risky. And again, it's not a trick that the SEC hasn't seen. So beware finders. Typical documents, we've talked about this a little bit. Organizational documents, I want those to be really good. One thing you'll find, if you start out with one type of company and then you move to another capital need, another kind of company, you're kind of ramping up. The scrutiny and the due diligence and attention to detail ramps up every time, right? The common mistake you see made, or a common mistake we see made, is somebody starts a company, does a friends and family raise, never thinks for 1 second, they're not even selling securities in their mind. They're raising money from friends and family. And so or they just issue stock to people because it seems like it's free. Okay, so you've got this weird looking cap table that's got the neighbor guy and the paper boy, and they're not sophisticated, they're not accredited, and then you get down the road a ways, you want to do a $20 million raise, and the VC's counsel, I guarantee you, will say, let's see your securities exemption analysis, all the memos, all the disclosure documents, subscription agreements that you used at the time of that offering. And people are like, what offering? That's just, we just sold a little stock, Sometimes we can clean those things up. way better to have it clean from the start. We'll understand, we better understand as lawyers, risk, benefit, value, that front end, you can only do so much disclosure. And frankly, even the VCs understand that as well. But there are times where they'll look and they'll say, that is so bad, we're not going to invest in your company. And that's really sad when you get to that point. So good organizational documents, they will change when you bring in more sophisticated investors because they'll demand more rights. If you ever want to look at what the kind of starting point, there's lots of different sets of sort of starting point. If you look at the website for the National Venture Capital Association, they got model documents. They have a term sheet. They have a registration rights agreement. They've got the articles and bylaws. They've got co-sale rights and right of first refusal. They've got a set of documents on there, and you can get an idea of what you're talking about in a preferred stock venture deal. And they can really make your head hurt. Subscription agreement, we talked about that. Form D is a filing with the SEC. Probably the most important point, common sense is not enough. I wish it was, because again, when I practice securities laws, I try to be pragmatic and practical and take an approach that makes sense. When you come to us for that purpose, hopefully we're working with you on the transactional side as well, the organizational side as well, but not always. And so when you come to us, what's your goal? I want to raise as much money as I need, and I'll talk to you about the business side of raising less money if you can. Raise the money I need with as limited amount spent on legal fees, as limited amount of delay, and as little complexity as we can have. But unfortunately, common sense isn't enough. Highly regulated, lots, big thick regulations that people smarter than me have to read and tell me what they say. But you want experienced, practical legal counsel. So you want somebody who's done this before, done it a lot, because it's you don't want somebody learning on your time or your risk, and follow their advice. So that's one of the driest areas of the law in the world. What questions can I answer for you? Yes.
How do convertible notes fall into the securities laws?
They are, in almost all contexts, a security just like others. So you should assume. Well, I'm sorry. The question was, how do convertible notes, how are they treated under securities laws? And the answer is really, if it's a security, all that applies. And a convertible note in all circumstances will be a security. I can't imagine, unless if you're getting convertible notes from your directors or officers. I mean, that's sort of why every once in a while you do have to think, because if you do all this securities compliance when you're doing it from your directors and officers, it's not a security. So you wouldn't have to do it. But for almost every other context I can imagine, it'll be fully covered. Yeah?
Are bridge loans treated any differently?
Bridge loans, it depends on how the bridge loan is structured. A bridge loan is usually going to come from a more sophisticated type investor, and the purpose of the bridge loan is typically something beyond the bridge, right? Why are we doing this, and what's the end game? So bridge loans are oftentimes integrated. Remember we talked about integration. So I can't really give you a blanket answer, except that bridge loans are generally maybe a little bit safer in the securities laws, but I want to know what the end game is, because bridge loans sometimes are convertible, oftentimes are convertible, and if that's the case, then we're almost certainly into all the full range of securities rules. But for the most part, the real question is, what's the end game? Okay. Yeah.
Is there a place you can get just for like friends and family type investments, get boilerplate documents, disclosures?
Yeah, no, I understand what you're saying. For a friends and family offering, I would strong suggestion is still that you go to a lawyer who's done those deals, and then you talk to that lawyer and you say, I need to know what this is going to cost me, right? So friends and family, the risk is lower in the sense that they're less likely to sue you, and you know them. You're not generally soliciting them. You still want to think about what do they do to your next round. Okay, and you want some clarity. So chances are with friends and family, let's assume you're doing $100,000 raise from friends and family, and you're going to bring in 5 people. It feels pretty safe And you can't go to somebody who's going to charge you $20,000 in legal fees for that. But what you do want to, having them sign a subscription agreement would be good. Giving them a little term sheet, maybe 2 pages. Here's what you get. For $20,000, you get X% of the company, and that is, and you may suffer dilution, and you'll have these rights under the operating agreement or under the articles and bylaws. We anticipate additional rounds of financing. You'll be diluted. What are your rights? What are our rights? What can we do with it? And then you would attach to that subscription agreement, and you have kind of a little stack of documents. Instead of a full-blown prospectus, you'll have this little maybe 2-page term sheet, a little couple pages subscription agreement, and the governing document. So articles, bylaws, and then when they later say, hopefully they don't, they're friends and family, right? But when they later say, I didn't understand. I thought, pick an easy one. Not that you misled me or anything, but I thought my $20,000 got me 10% of the company, and it only got me 5. Well, oops. That's a fight you don't want to have. That's easy to disclose and make really clear. Or the other one, there are people out there who think that they'll never be diluted. So if I put in, it's amazing to me but I practiced in the area and been had no dilution. So people who put in $20,000 and are told that they'll get 5%. Then they think when you go out and raise $1 million, $5 million, $10 million, $20 million, they still will own 5%. Once in a while, people want to do that, non-dilutable shares, which is almost always a crazy idea. But some level of disclosure. There are sample. You can find publications with sample documents. I'm not a fan of like LegalZoom. I've seen a lot of mistakes made that way. I'm not a fan of people just taking something they've seen from another deal. The example I gave earlier, exclusive versus inclusive, dropping out the word not or except, that stuff happens. And so you can remember I said a little compliance can add a lot of security, can protect you a lot. So, if your lawyer is practical about things, they'll understand. They'll give the classic CYA. They'll send you an email. I'll send you an email that says, "Look, if we could, we'd do a lot more disclosure than this. But under the circumstances and given your budget and the risks of this offering, this is what we advise you to do." And it's a lot better than nothing. All right. Thank you.